Good morning to you all. We're honored to have you participate in our regular land reform update. This is what we usually do to connect with our clients, our potential clients, and really to contribute to national policy and discussions around issues that we in our practice grapple with on a regular basis. So our land reform practice has really been in the cutting edge of policy and legislative changes and developments in this area. And this morning is no different. We are going to be looking at various themes and topics that we think are burning issues in the relevant industries. I'm not alone as usual. I'm supported by my very able team. And just in terms of introductions, my name is Bulelwa Mabasa. I'm a director and head of the Land Reform, Restitution and Tenure practice at Worksmans. I am supported by my co-director, Ati Jaha, who is an expert in mining and environmental law. She will be taking you through a topic of particular interest at the moment, which involves the wine environmental system. And she will be speaking to that together with Thomas Carberg, who is an associate in my team with a great interest in expropriation and land reform issues. And I'm also joined by Refilwe Muti, who will be taking you through the spatial planning legislation and how it interacts with mining and environment. She is a senior associate in my team, together with Butumelo Modi, who's also a senior associate, and her having done quite a number of work in the evictions part of land reform. She'll be taking us through her experiences, the pros and cons of what has occurred in the context of the national state of disaster. Last but not least, I'm sitting next to Siposetu Zazela. He is a candidate attorney, and he has been instrumental on the topic that we'll be starting with, which is a little bit outside of the land reform discourse, but we think it's not too far away from the work that we do. We've built this practice also on administrative and constitutional law principles. And so therefore, issues around state procurement and the future of state procurement in light of the recent constitutional law judgments have become quite critical. And so without further ado, perhaps before I do that, we would like to engage with you. We don't want this to be a lecture. We want to connect with you. We want to know what your burning issues are. Please use your comment section as generously as you would like. We would like to keep this as interactive, as engaging, and hopefully be able to also learn from you. So without wasting any more time, we will start the presentation by Siposetu as we look into the issue of the future of state procurement as it relates to the broad-based Black economic empowerment policy in the country. So over to you, Setu. I'll just go to your... So,
Good morning, ladies and gentlemen. As introduced, my name is Siposetu, and I'll be speaking on changes in procurement legislation, particularly as it relates to the future of state procurement and the broad-based Black economic empowerment policies in the country. Now, as you might have noted, legislation in state procurement has been on the change over the past couple of years. It can be attributed to numerous factors, but for our purposes particularly, we can look at the factors of the technical efficacy of the legislation and as it relates to the addressing of historical exclusion of the majority Black population in the country. South Africa's history, socially and economically, has seen the Black majority being excluded from participating in the economy, which then gives rise to provisions in the Constitution, such as Section 217, relating particularly to our topic today, as well as Section 9 relating to equality. And it is therefore trite that any legislation as it relates to these topics is interpreted in line with these provisions in the constitutions, right? So these provisions have seen the enactment of legislation and accompanying regulations, such as the Broad-Based Black Economic Empowerment Act and the Preferential Procurement Policy Framework Act. I see my slides have not been moved in.
I'll sit next to you and then I'll drive the slides as you speak.
Thank you.
Yeah.
So to continue on where we're at, so these provisions, Section 217 of the Constitution and Section 9, have seen the promulgation of legislation such as the Provincial Policy Procurement Framework Act, as well as the Broad-Based Black Economic Empowerment Act, right? And the manner in which this mandate of addressing historical exclusion in state procurement and in the economy, and particularly state procurement, has been a topic of contention. And this then brings us to the recent judgment of Agribusiness, which we'll be focusing on, because it is that judgment that has triggered the conversation that we're currently having today on where state procurement lies in relation to Black economic empowerment. So as previously mentioned, the judgment has triggered a long-standing conversation as it relates to the socio-economic standing of state procurement and the legislation in that regard. So as mentioned, state procurement is regulated by Section 217 of the Constitution, and 217 permits organs of the state to create policies, right, and categories of preference as it relates to the allocation of contracts, as well as providing for the protection or the advancement of categories of persons which are disadvantaged by unfair discrimination. Then we move on to Section 2173, which then provides that national legislation should be implemented to prescribe a framework according to which these policies in Section 2172 will be implemented. And now this framework or these policies and this legislation that is being spoken of in this regard is the Preferential Policy Procurement Framework Act. Pretty long title, if you ask me. In 2011, as it pertains to this, the National Treasury received complaints from various stakeholders, small, micro, medium enterprises, relating to the efficacy of the regulations in the Procurement Framework Act in addressing the issues of historic disadvantage and the inclusion of previously excluded individuals in the business of state procurement. And the conclusion, well, the process resulted in the establishment of a task team to investigate and to address these concerns. And the advice that the task team ended up giving the minister is that what is essentially required is a flexible and a standardized approach to address these concerns. The approach that was to be adopted was one which balances these requirements or these goals of addressing of basically creating reform as well as competitive pricing. And so we saw the promulgation then of the 2017 regulations to the Procurement Policy Framework Act, right? So what these regulations did was to allow for the placing of pre-qualification criteria, which allowed only certain groups of tenderers to respond to tender advertisements. So these would be tenders that had a stipulated minimum BEE rating, tenders who were exempted micro enterprises, qualifying small enterprises, and tenderers who were going to subcontract a minimum of 30% of the tender to a qualifying small enterprise, or a cooperative which was owned by at least 51% Black people, Black women, Black youth, Black people with disabilities, Black people living in the rural areas or underdeveloped areas or townships. Now, we've got these regulations and which were aimed at addressing these concerns. And now we have these recent judgments, the Supreme Court of Appeal judgment and the Constitutional Court judgment, basically challenging the validity of these regulations. So the court in the Supreme Court of Appeal stated that basically went and referred to the Preferential Procurement Act in evaluating whether it is that these regulations as promulgated by the minister were valid in their purpose as it relates to the Procurement Act. So the court looked at Section 5, which constrains the minister's powers to make regulations regarding matters which are necessary or expedient for the achievement of the objects of the Act. The court stated that Section 2 of the Act requires the creation of a framework, as we previously mentioned, framework for the implementation of the procurement policy. Now, in terms of the regulations, the implementation of the pre-qualification criteria by an organ of the state was discretionary. The regulations did not, however, provide for a framework which will guide organs of the state in the exercise of such discretion. But just in a nutshell, the Supreme Court of Appeal basically concluded that the regulations that the minister had enacted were ultra vires. They were outside of the powers that the minister had granted, and therefore, because of that, they were invalid. Right. Just to recap again, these were the regulations that were aimed at addressing the Black economic empowerment concerns in state procurement. And we waited for the Constitutional Court judgment. The court considered the facts of the case and looked at the act once again and the powers that it grants the minister. So essentially what the act does, it states that the minister has power to promulgate regulations which are either necessary or expedient for the achievement of the purposes of the Procurement Act. And the court concluded upon its interpretation of the act that the regulations were neither necessary nor expedient for the achievement of the purposes of the Act. Now, if we look at interpretation and the journey of interpretation in South African jurisprudence, we find that the method of interpretation that the court usually assumes is that the court should not lean towards interpretation that is more business-like or technical. It should, however, lean into interpretation that is aimed at achieving the goals of the Constitution. The court should be able to balance those two. I thought we should just keep that in mind as we consider the court's interpretation of necessary and expedient, right? So once again, the court stated that the regulations are neither necessary nor expedient. Now, if we look at the Preferential Procurement Policy Framework Act, we see that the Act attempts a balancing exercise in terms of the goals as set out in 217 of the Constitution. So 217 once again states that in implementing policy, it needs to be competitive in pricing, but also address the issues of reform in state procurement. Now, the Preferential Policy Framework Act basically lays out how this is supposed to be achieved, and we see that we find a point system. We've got the 80-20 point system and the 90-10 point system, right? We see that 80 points are allocated primarily to pricing and only 20 points to the goals of reform. And in the same with 90 points and 10 points in the same manner. And then we find that we've got Section 2(1)(f) basically stating that where it is that the tender is not to be granted to a tenderer that has the lowest price, objective criteria must be given to that, right? Now we see that the issue of historic disadvantage has already been addressed by the 80-20 and the 90-10 point system, because the 20 points have been granted to addressing the issues of reform, and 10 points have been granted to addressing the issues of reform. And naturally then, it cannot be that the legislator would interpret 2(1)(f) the objective criteria to once again have these objective criteria be goals of reform, right? So essentially then what we see is that the only protection or the only covering that goals of basic broad-based economic empowerment have received are of the 20 points and the 10 points granted in state procurement, which is rather minuscule, if you ask me, in terms of achieving the goals of reform, right? And so it then brings to the question then what it is that the court's the future of state procurement will look like, owing to the interpretations that the Constitutional Court had with regards to the provisions of the State Procurement Act. They stated that the promulgated regulations in the 2017 promulgated regulations were neither necessary nor expedient and were therefore set aside. And now we see that the Policy Procurement Framework Act only provides for this amount of protection, or protection for broad-based Black economic empowerment, right? This then rather leaves the goals of reform in the lurch. And so if we think then about state procurement as it pertains to the future and what it is that is coming forth, particularly as it relates to South African legislation not having a unitary stance on where it is in terms of the goals that it has in state procurement, because there isn't a stance taken in terms of the goals that the South African state has. Are we leaning more towards competitive pricing, or are we leaning more towards all reform? That has always been the balancing exercise that we had seemed to have to achieve. But this recent constitutional judgment then lays it out to us. It states that when interpreting these, well, it appears to us that when interpreting these provisions and the goals of economic reform versus competitive pricing, the court is most likely then to lean towards competitive pricing in state procurement. Thank you very much.
Thank you, Setu, for that input. And I think really, without, I don't have the benefit of seeing if we have any questions that arise from this, but please, I do encourage you to continue to do that. I think really the high watermark of this constitutional judgment, as it relates to the BEE versus state procurement, is that this is an opportune time in our history where we need policy guidance and policy direction from Parliament and with the executive to determine whether or not state procurement in itself is a tool that can be used as part and parcel of our economic redress objectives. So without really wasting more time, I do think that as part of our agenda, we have Tom and Ati to talk to us around a very, very topical issue in the mining sector, which is really a matter that we grapple with all the time in our practice. Also having matters that we are currently underway that are very similar to the Shell judgment. So they will, Tom and Ati will take over from me, and there'll be a particular emphasis also on where communities lie as there is exploration and economic developments and all of these economic factors. So they're going to deal with that topic together, but I think Ati will start first, just laying out the law as it relates to the environmental factors, and Tom will then follow with the focus on communities. Thank you.
Thank you very much for that lovely introduction, Bulelwa. Much appreciated. Good morning, all. The National Environmental Management Act, which is also known as the NEMA, introduced the environmental management regime in South Africa. This includes the environmental impact assessment process, also known as the EIA. In this regard, Section 24(2) of NEMA empowers the minister responsible for environmental matters, who is now the Minister of Forestry, Fisheries and the Environment, to publish listed activities which impact on the environment and which may not commence without an environmental authorization. Pursuant to these empowering provisions, the minister promulgated the EIA regulations, with the latest version being the Environmental Impact Assessment Regulations of 2014. These were amended in 2017. The consequences of commencing with a listed activity without an environmental authorization is that it's an offense in terms of Section 24F of NEMA. There's also an administrative fine of up to 5 million, which may be paid for a rectification application in terms of Section 24G of NEMA. So there are serious consequences of commencing and even continuing with the listed activity without an environmental authorization. So over the years, there have been a number of sets of EIA regulations and listing notices, with the earliest version having been published under the Environmental Conservation Act of 1989, or the ECA. Following the NEMA coming into effect in 1998, there was another set of EIA regulations that were published in 2006. These were then replaced by the 2010 EIA regulations. So there's been much development with regards to the EIA regulations, and in particular, the listed activities that would be triggered and which would require an environmental authorization. Currently, when we talk about the EIA regulations, we refer to the 2014 EIA regulations, which were also published in terms of the NEMA. These 2014 EIA regulations were amended in 2017. So there's a new list and 3 listing notices of listed activities which would trigger the requirement for an environmental authorization. So together with the new listing notices in 2014, the government introduced or rolled out the One Environment system with effect from 8 December 2014. This was in order to streamline the licensing processes for mining, environmental authorizations, and water use. Under the One Environment system, the Minister of Mineral Resources and Energy will issue environmental authorizations in terms of the NEMA and waste management licenses in terms of the National Environmental Management Waste Act for mining and related activities. However, the Minister of Environmental Affairs remains the appeal authority in respect of these authorizations. Following the One Environment system, the Department of Mineral Resources became the competent authority for all prospecting, mining, exploration, and extraction of mineral and petroleum resources, or any activities directly related thereto. The then Ministers of Environmental Affairs, Mineral Resources, and Water and Sanitation agreed to fix timeframes for the consideration and issuing of permits, licenses, and authorizations in terms of the relevant pieces of legislation. These ministers agreed to synchronize the process for issuing permits, licenses, and authorizations within a period of 300 days. In the event that a decision to issue a license or authorization is appealed, an additional maximum period of 90 days is provided for legislatively to finalize the process. However, in practice, these departments rarely adhere to these timeframes. So environmental management plans, also known as EMPs, and environmental management programs, also known as EMPRs, approved in terms of the Mineral and Petroleum Resources Development Act, or the MPRDA, immediately before 8 December 2014, were deemed to be approved in terms of NEMA and regarded as environmental authorizations for purposes of NEMA. Therefore, all EMPRs that were approved prior to the introduction of the One Environment System were regarded as environmental authorizations for purposes of compliance with the environmental legal requirements. However, all applications lodged after the commencement of the One Environment System were to be processed under NEMA, and the processes prescribed under the EIA regulations of 2014 for obtaining an environmental authorization were to be adhered to. These processing, depending on the listed activity concerned, would be a basic assessment report, or a full scoping and environmental impact assessment report that would be compiled, just depending on the impact on the environment and the listed activity concerned. The introduction of the One Environment System has resulted in many legal difficulties. These legal difficulties were considered by the court in the Shell case and will be discussed in greater detail by my colleague, Tom, who's seated right next to me. Tom, over to you.
Thanks, Ati, and thanks to Bulelwa and Setu and everyone for I think, excellent presentations so far. So I'll be dealing with this recent Shell judgment, which was obviously a matter of great national concern. Everyone will know that the Shell case concerned a proposed seismic survey to be done by Shell off the wild coast of South Africa. The wild coast is an area which many people regard as having spectacular natural beauty. It's also home to many different species of marine mammals like dolphins and whales. The way that Shell was going to conduct the survey was a seismic survey which involved a seismic or air pressure gun, which is mounted to the underside of a vessel called the Amazon Warrior. That was it led to national protests and ultimately culminated in an interim interdict, which was granted by the Eastern Cape High Court on the 28th of December 2021, so just in time for the new year. Shell, after the interdict was granted, Shell attempted to appeal it. They failed to obtain leave to appeal on the 17th of February, and currently the main application is set down for 30th of May of this year. So what this means is that there's currently an interim interdict in place, which means that Shell is prohibited from conducting any seismic surveys until the matter can be more fully considered by the High Court on the 30th of May. And the relief that the applicants are seeking is a final interdict, and actually also involves declaratory relief to the effect that Shell will never be able to conduct the seismic survey unless they obtain an environmental authorization, which Ati spoke about earlier. And it was not a so the court in this interim interdict the judgment didn't make great reference to the applicability of the One Environmental System, but it will be instrumental. It will be a point on which the court's judgment will turn in the main application, because it has great implications on whether Shell is allowed to conduct a seismic survey. But let me just discuss the judgment in a little bit more detail. So in order to obtain an interdict, the applicant has to demonstrate three things: a clear right, reasonable apprehension of irreparable harm, and the fact that there's no satisfactory alternative remedy present. The most interesting one here is the basis on which the applicants showed that they had a clear right. I'll discuss it in more detail just now. On the point of irreparable harm, the applicants demonstrated that there was a great deal of expert evidence that they submitted, which showed the impact of seismic blasting on marine life, particularly because a lot of the mammals in the area, like dolphins and whales, use echolocation or to communicate and for mating rituals and so forth, which would obviously be harmed by the seismic surveys that Shell intended to use. The last point is the satisfactory remedy, and that was actually quite interesting because in the case, the Minister of Mineral Resources, Gwede Mantashe, seemed to very clearly be biased in favor of Shell. And the court actually referred to that and used it to conclude that the applicants didn't really have any. There's an appeal procedure that they could have used, but the procedure would not offer them the relief that they seek because the minister was quite clearly biased in favor of Shell, and he actually made comments to the effect that infamous comments to the effect that the applicants are colonialists of a special type, which was received with great consternation from everyone. Yes, so why is the Shell case important? The Shell case was quite a groundbreaking precedent in that it affirmed the importance and the validity of spiritual, religious, historical, and economic, religious, and historical connections with the sea, and obviously also the economic importance of the sea to the applicants. These kind of rights are protected by certain sections of our constitution, namely section 24, which is the right to an environment, section 30, which is the right to participate in the cultural life of your choice, and section 31, which is the right to enjoy your culture, practice your religion, and the right to language. So these kinds of rights have not in the past been, or the importance hasn't really been vindicated in the courts as much. And the Shell case is is an important precedent in that regard. Another reason why the Shell case is so important is because it emphasized the importance of adequate consultation with interested and affected parties, which is a requirement under the MPRDA before any mining can commence. I referred to this earlier with regards to the clear right that the applicants had to establish. And the court went into a lot of detail in criticizing the manner in which Shell consulted with the community. So I'm going to just go into that a little bit because it's very important. In effect, what Shell did was they had their own stakeholder database, which they generated based on their previous interactions in the region and based on the connections that they had. The people that were part of this database included government authorities, NGOs, various community-based organizations, and local fishing industry groups. But the applicants are rural fishing communities that are along the coast, and the applicants didn't form part of that list. The Shell included newspaper advertisements they advertised the mining in newspapers, but they were only published in English and Afrikaans, not in Sizulu or Xhosa, which are obviously the local languages that the applicants use. Shell also didn't use any radio advertisements, and ultimately, another point was that they consulted with various kings in the area, and they concluded that the kings would represent all of the locals in the area. The applicants later on came to court and said that these kings had no authority to represent them or to speak for them. And the court actually was quite harsh in its criticism of Shell and said that the way that they consulted was reminiscent of the consultation that would be done during apartheid. So it's a kind of a colonial mindset almost that they had, which is very interesting. And it just goes to the heart of the importance of actually and genuinely consulting with these affected communities. And I think this sentence sort of summarizes the case quite well. The court says that what this case is about is to show that had Shell consulted with the applicant communities, it would have been informed about those practices and beliefs. So that refers to the religious, historical, and economic connections that the applicants have with the sea, and would then have considered with the applicant communities the measures to be taken to mitigate against the possible infringement of those practices and beliefs. I think that the importance of the Shell judgment is made even more clear when one considers the context that it's in. And the outcome in Shell is not the result of an overzealous judge, but it's actually just the latest chapter in this sort of emerging jurisprudence that has emerged over the last few years, which emphasizes the importance of meaningful consultation and also the importance of informal rights. So I'm going to spend just some time. Sorry, I'm actually skipping ahead a bit here. Sorry, before I go to that, I just want to spend a few moments on Shell in the context of the one environmental system. Sorry, I just got a bit ahead of myself there. So as I mentioned earlier, the judgment didn't make great reference to this aspect, but the applicants made long submissions on the importance of the one environmental system and what it means for the case. So essentially, the difference here is that the applicant's position was that an environmental authorization would always have been required, even prior to the one environmental system. And I think this is a view that Ati shares as well. So essentially, the minister's position here was that they obtained an authorized environmental management program in terms of the Mining Act, and the minister's view, Shell's view, was that EMPR constituted an environmental authorization for purposes of NEMA. The applicant's view is that that's not the case and that they would require both. So they would require an EMPR as well as an environmental authorization. And essentially the heart of the applicant's case is that NEMA provides it's obviously environmental legislation that's geared towards protecting the environment specifically, whereas the Mining Act is obviously not geared towards specifically protecting the environment. So an environmental authorization under NEMA is much better suited to addressing environmental concerns, and that's why it's critical that both are necessary. So as I've said here, the applicant's position was that environmental concerns were inadequately addressed by the EMPR. It was also an outdated EMPR, and environmental authorization under NEMA would be better suited for protection. Their position was that an environmental authorization would always have been required even before the OES took effect. In the judgment, the court, as I said, didn't make great reference to this, but he did say, the judge did say that the applicants have prospects of success with their stance in the main application, which, as I said, will be heard later this month. So now we arrive at just Shell in context, and I just want to spend a few minutes just explaining the sort of emerging jurisprudence that we've seen over the last few years. So I'll be covering 4 important cases, which are Maxand, Bengwenyama, the third one, Malaydu, and Colobini. The first one, I'm going to just go through these quickly. So the first one is Maxand. In essence, what Maxand was about was the interplay between the Mining Act, NEMA, and the Land Use Planning Ordinance, which is also known as LUPO. LUPO deals with land use zoning, and in this particular case, the property concerned was not zoned for mining. The minister's stance was that the MPRDA trumped LUPO because the MPRDA is national legislation versus LUPO, which is just an ordinance. The ultimate outcome was that the court said that the Mining Act does not have a special preference when it conflicts with other laws. So in other words, it means that the MPRDA doesn't trump other legislation if it conflicts with it. The second case is Bengwenyama, which is sort of a seminal case about the importance of meaningful consultation. It involved a company called Genoa Resources, And just to put it in a nutshell, the consultation that Genora went through was described as a box-ticking exercise. They would furnish the local communities with forms on which they could indicate yes or no, whether they agreed with the mining or not. And the court said that that was inadequate, and the consultation needs to be meaningful and genuine. It needs to be a good faith attempt to actually engage with the community on the issues and try to find solutions. The third case is Malaydu. And so in this case, there was a company called Interplay and IBMR. They obtained a prospecting right over a certain piece of land, and they concluded an SLA, a surface lease agreement, with a tribal authority. And essentially what the importance of the case was that there were certain applicant communities who said that they were not represented by this tribal authority, and that the tribal authority didn't have the authority to speak for them. The court ultimately concluded that the respondents, or rather the applicants, didn't have an actual chance to engage on the conclusion of the surface lease agreement, and declared it and set it aside. And so what this case was about was, again, the importance of proper consultation, as well as the importance of informal rights in terms of legislation like the Interim Protection of Informal Land Rights Act. The last case that I want to just speak about is the Colobini case, which is also quite a recent case. It's again spoke about the importance of IPILRA. So I just want to quickly spend a few minutes on that. So IPILRA essentially protects informal rights, so which are unregistered rights in land. And Section 2 of IPILRA says that when a holder of an informal right is deprived, or rather that they cannot be deprived of their land without their consent. And that's important because, as we've said before, the Mining Act requires consultation, but IPILRA actually requires consent. And so what that actually means is that if you hold informal rights in terms of IPILRA, this latest case is a precedent to say that not just consultation needs to take place, but there actually needs to be consent, which is a very controversial development, because in a sense it elevates the holders of informal rights over the holders of common law property rights, because it requires, as I've said, consent as opposed to just consultation. So ultimately, just to conclude, what we see here is that the Shell judgment is really the latest chapter in a development of this emerging jurisprudence, which has affirmed the importance of proper consultation with communities, the importance and validity of informal and unregistered or customary land rights, the spiritual, religious, and cultural connections with land and with the ocean. And stakeholders in the sector need to be aware of this jurisprudence in order to avoid costly litigation and reviews. So that concludes my presentation for today. Are there any questions? I can't see them at the moment, but are we going into a break or going straight to? Okay. All right. So I'll hand over to my colleague, Refuli Moitse. She's a senior associate, and she'll be speaking about the importance of land use zoning. Over to you.
Thank you so much, Tom, for the introduction, and very well done on a brilliant presentation with Ati. Please excuse my voice, it's a bit husky this morning. I think I'm coming down with the flu. So what I'm really going to be presenting about is the relevance of land use zoning, and particularly the interplay between mining and environmental law. This is so important because it links to the topic that Ati and Tom have just presented about. And particularly the common denominator there is the importance of public participation, public consultations, and meaningful public consultations. So I'm really going to be taking you through what the law, insofar as land use and spatial planning, says about the importance of making sure that land is properly zoned for the purpose, especially of mining and for whatever purpose, but we are going to be focusing on mining mining activities today. So land use and spatial planning in South Africa is regulated by Pluma, which is the national legislation really, that regulates spatial planning and land use in South Africa. There are, of course, provincial ordinances, as Tom has already mentioned, LUPO, which is for the Western Cape, and which regulates land use from a provincial and municipal perspective. So spatial planning really, as Pluma applies to the entire South Africa, was enacted in terms of Section 157 of the Constitution from a national point of view, as well as Section 44 of the Constitution from a provincial perspective. And Pluma says, except as provided for by Pluma, no other legislation provided that is inconsistent with Pluma. Except as provided for by Pluma, no other legislation may provide for any legislation inconsistent with Pluma. Apologies. So the purpose of Pluma really is summarized in 5 core principles, which is spatial justice, spatial sustainability, spatial reliability, efficiency and equality, and good administration. So Pluma really was enacted for the purpose of giving effect to Section 24 of the Constitution, which provides for the right to a clean and protected environment, including a land use planning system that is protective of environment. Section 25, which speaks to property rights, including measures that enable citizens to gain access to land on an equitable basis. Section 26, which speaks to the right of access to land on a just and equitable basis. So now I am going to be moving forward to particular provisions of Pluma that speak to rezoning. So Section 24B of Pluma provides that a municipality must, after public consultation, adopt a land use scheme which takes cognizance of and complies with environmental management laws. Section 28 then provides that a land use scheme may be amended by rezoning by a municipality. However, prior to that amendment, the municipality must undertake an intensive public participation process. And after the public participation process has been undertaken, then the Minister of Land Reform and Rural Development must provide guidance to provinces and municipalities. And the amendment to the land use scheme may only be authorized or approved by a municipal council. Section 29 speaks to the intergovernmental framework, which speaks really to the cooperation between different spheres of government to give effect to the amendment to a land use scheme. And Section 29 particularly mandates a municipality to consult with any organ of state that is responsible for administration of legislation and approvals that relate to any activity that falls within the ambit of Pluma in order to avoid duplication, and may, after this process, enter into an agreement with the relevant organ of state in order to avoid duplication on submissions of information relating to an activity that requires authorization. And after conclusion of the agreement, the Municipal Tribal Authority may take account over any processes, Municipality Planning Tribunal, may take account over any process under any legislation as authorized by the written agreement, insofar as any requirement need to be met under Pluma. So, for example, I will give an example. So, when it comes to rezoning of property, there are several laws that would need to be complied with. So, for example, insofar as a mining area is concerned, in addition to Pluma, a party would need to also comply with the MPRDA and obtain the necessary approvals from the Department of Mineral Resources and comply with the National Water Act, likewise, and obtain approvals from the Department of Water and Sanitation. And when it comes to agricultural property, compliance has to be had with, amongst others, the Subdivision of Agricultural Land Act, and luckily, the party would need to obtain, the approvals from the same department that authorizes Pluma. We will then move to Section 30. Section 30 provides that when activity requires authorization in terms of Pluma and another piece of legislation, the relevant municipality and organ of state may authorize such an activity by granting either one, an integrated authorization or separate authorization. In the event that an integrated authorization is to be granted, there needs to be compliance with all pieces of legislation. The authorization ought to specify the provision in terms of which it has been granted, and the relevant authorities have authorized it. Thereafter, a municipality may regard an authorization that was granted in terms of any piece of legislation but meets all the requirements of Pluma as having been granted in terms of Pluma. So we then move to the jurisprudence, which really speaks about the importance of rezoning of properties. I'm not going to focus much on the Maxent case, as Tom has already elaborated on that. But just to recap what he said, Maxent basically highlighted the importance of having property zoned as mining property, and more fundamentally that the MPRDA does not trump any piece of legislation, whether provincial or local. Then the last case that I'm going to be discussing, which the facts were a bit different from Maxent, is the Insinu Conservancy versus Tronox case at Insinu. So in this case, Tronox was granted an old order mining right in 1998, and in 2013, an NGO brought an interdict application to stop it from conducting its mining operations pending approval from the municipality. And the issues really that needed to be determined by the court was whether the town planning ordinance of 1949 required Tronox, to obtain rezoning insofar as the mining area is concerned. Tronox then commenced mining prior to the requirement of rezoning when it obtained its old order mining right. However, it was granted a converted mining right in respect of the old order mining right in July 2018. Tronox's case or argument was that the amendment of the TPO, which required consent for non-agricultural purposes, which was promulgated in 1992, and the only authority required to mine was as required by the Minerals Act. The TPO was furthermore amended in 2008 to include mining as an activity that required provincial planning authorization. And when Tronox commenced with its mining operations, the TPO did not require planning approval and mining. So what the court said was it took into account the regulation of a mining authorization in terms of the Minerals Act on the one hand, which provides that the provisions of the Act are only subject to other national legislation related specifically to the mining industry. And the Mineral Act adequately caters for the physical and environmental control, and therefore a holder of a mining right need not have further consent or permissions. So that really concludes my presentation. Please do feel free to chat in the chat box regarding any questions that you may have about my presentation. Thank you so much. I will then hand over, to my colleague Beebe, who will be presenting on evictions in the context of the disaster management regulation. Okay. Oh, sorry. I've just been alerted that we'll be having a Q&A session at the end, and all questions will be addressed at that particular period. Thank you.
Yeah. My slides will come up. Good morning, everyone. Thank you, Rafila, for that introduction. My name is Beebe Modi, and I'm a senior associate at Worksmans. And today I'll be addressing you on the impact of the declaration of a national. The impact of the national state declaration of a national state of disaster on evictions in South Africa, particularly focusing on evictions from residential property. Sorry, I'm just getting my bearings. So on 15 March 2020, the president declared a national state of disaster and announced an immediate national lockdown with effect from 26 March 2020. I know we thought that it was going to be for 21 days, but it turned out to be much, much longer. So these were obviously unprecedented times for us. These were obviously unprecedented times for us, and we as South Africans had to change or shift the way that we do things. The president also announced different alert levels. I think it was alert level 5 to 1, and these differed depending on the restrictions that were in place on the movement of persons, etc. What's wrong with my slides? Oh, okay. All right. So during alert level 5, the president, I think, announced regulations, well, promulgated regulations on 16 April 2020. And regulation 11 of these regulations that applied to alert level 5 strictly prohibited evictions. So there was a strict moratorium on evictions, and there was no recourse for property owners. You couldn't go to court. Eviction applications were not heard. So during alert levels 4 to 1, the regulations were slightly amended to allow for the hearing of eviction applications, and the courts could grant eviction applications, well, eviction orders. However, the regulations placed strict requirements on property owners seeking eviction orders. So the regulations provided that the courts may suspend the execution of eviction orders until the uplifting of the national state of disaster. And one would think the use of the word may meant that there would be a discretion on the courts on whether or not to grant eviction orders and the immediate execution of such orders. But this discretion was not unfettered. So while courts could grant eviction applications, the regulations provided as a proviso that the courts could only authorize immediate execution of eviction orders if it was in the courts. Sorry, I'm trying to also follow my slides because they were slightly changed. But if it was in the court's opinion that it would be just and equitable to grant the immediate execution of orders. Furthermore, the regulations also provided for factors that the court should take in place when considering whether to grant immediate execution of eviction orders. These included factors such as the impact of the disaster on the parties, the prejudice to property owners versus prejudice to unlawful occupiers, the prejudice to an unlawful occupier to access legal services, the immediate access to alternative accommodation, and measures to protect the health of anyone in the process of relocations. As we know, evictions can require a lot of manpower. It's not just the sheriff who goes and serves the order. The sheriff often uses a lot of manpower, service providers, relocators, moving companies to execute these evictions. So these are part of the factors that the court would take into consideration whether to grant an immediate eviction order or not, or suspend it until the lifting of the national state of disaster. Factors such as the harm to others or a threat to life, and the reasonable steps that a property owner would have taken to make alternative arrangements with illegal occupiers, such as payment arrangements where a person is owing rental and where that is the reason for you seeking an eviction order. The regulations also provided that the courts could request a report from the responsible member of the executive regarding alternative accommodation, the availability of isolation facilities, etc. So in my experience and having dealt with a few eviction applications during the national state of disaster, the courts were very inconsistent with their approach to eviction applications. So I had two matters in the same court that were largely similar, very similar facts before the courts. And on the one matter, I was granted immediate eviction order. And on the other case, the order was suspended until the national state of disaster has been uplifted. A lot of courts didn't even consider these factors, to be quite honest. I think a lot of courts were very cautious in granting immediate evictions, particularly in the current state that the state that we were at the time. The infection rates were high at some levels. For example, alert level 4, the infection rates were still high. There were still restrictions on movements of people, and there was still restrictions on the movements of people, and it would have been difficult to execute on an order and to require people to just seek alternative accommodations during those times. And I think the courts then were very cautious in their approach of eviction applications. One could argue that, like I said, during alert level 4 and 5, there was a lot of restrictions in place, and therefore the regulations at that time made sense. But during alert levels 2 and 1, the restrictions on our movements eased, and the infection rates actually declined so drastically that during alert level 1, I think we were starting to go back to some sort of normalcy. So during those times, the regulations were frustrating to a lot of property owners because you still couldn't get an eviction order, or you could get an eviction order, but the execution of it was suspended until the end of until the uplifting of the national state of disaster, much to the frustration of property owners. Whereas on the one hand, people can move around, people can start to gather, and infection rates are low, and you can't exercise your own property rights. One would also then need to consider whether the regulations in relation to evictions during the national state of disaster constituted an unlawful deprivation of rights, or whether any such deprivation was justified in the circumstances. I think I just spoke about the different alert levels and how they impacted our movement and how infection rates were at that time. Section 25 of the Constitution provides that no one may be deprived of property except for in terms of a law of general application, and that no law may permit an arbitrary deprivation of property. That's the general rule. There's no law that can permit an arbitrary deprivation of property. Section 25(2) in turn provides for an exception to this general rule. And it provides that property may be expropriated in terms of a law of general application for public purpose or in the public interest, and subject to compensation. Section 36 of the Constitution, which is, Section 25 of the Constitution is contained in the Bill of Rights, and we know that that's the cornerstone of our law in South Africa. And Section 36 of the Constitution provides for a limitation of these rights. As we know, the rights contained in the Bill of Rights are not absolute, and they can be limited in certain circumstances. In order for a limitation on rights contained in the Bill of Rights, which a right to property is included in, to be lawful, there's certain factors that need to be taken into account, including the nature of the right, the importance of the purpose of the limitation, and the nature and extent of the limitation. Factors such as that the limitation must apply to all people and not just one person or group of people. The limitation must be reasonable and justifiable in an open and democratic society, and the limitation must be based on human dignity, equality, and freedom. Section 37 of the Constitution provides that any legislation that derogates from the Bill of Rights must be strictly required by an emergency. Section 37(3)(a) of the Disaster Management Act, which was the legislation that the regulations were based on, or promulgated in terms of, provides that the regulations must only be exercised to the extent that it's necessary for the purpose of assisting and protecting the public. So one would have to ask whether these regulations, particularly pertaining to evictions, have gone beyond the ambit of Section 36, Section 37(4), and Section 30 of the Constitution and Section 27(3)(a) of the Disaster Management Act. It is a balancing act. On the one hand, we have property owners who have rights that are protected in terms of the Bill of Rights, and on the other, we have unlawful occupiers who at the time, at certain points during the national state of disaster, could not do anything about moving around, looking for alternative accommodation. The infection rates were high, and I guess during that time, one could say the rights of these illegal occupiers would take precedence over the rights of property owners. But at certain points, I do think that the regulations went beyond the ambit of these sections that I've just mentioned. Where we are right now is that evictions are back in full force in courts. Courts are hearing eviction applications. The people that were granted orders during the national state of disaster can execute on these orders. There are transitional regulations pertaining to the management of COVID-19 that provide for transitional matters during the next few days. I think 2 days, the last day that the transitional regulations are in place, but I know that there are new regulations that also provide for the wearing of masks, etc., that are still in place until the 5th of July 2021. But evictions are back in full force and following the lifting of the national state of disaster by the president. And that concludes my presentation today. If you have any questions, please feel free to engage with me in the comments and answer section.
Thank you, Dumi. Thank you to Refilwe and Dumi. I think really what the recurring theme that you would have realized, when we designed today's program, was to delve into issues around the state South Africa, the capability of states to run institutions, where the law fits into all of this, and how COVID has also had an impact in how citizens interact with land and the laws that are made in relation thereto. So really just to put everything all together, we're left with a question mark and a remark that asks the question around what then do we do as BEE, it being an enabling tool for future economic development based on the outcome of the Constitutional Court, and what then is the role of Parliament in ensuring that the reform objectives do not get lost in the context of procuring goods and services from the states, from emerging enterprises, QSEs, and Black people in general. And then, of course, when we come to the issue around public consultations, there was a very interesting question that was asked in the Q&A. I think it was by Mr. or Ms. Mudimu. Please forgive me if I've butchered your name. You wanted to know about the role of technology in the context of community consultations. And I think that's an interesting question. I've once been approached by a community based in Ndabakazi in the Eastern Cape, where they had academic institutions, cosmetic companies that had done a scientific study on a plant that had grown exponentially in their land, and they needed to be consulted, but we couldn't, as part and parcel of helping the community, could not get an address. The community couldn't be tracked on a map. There were nowhere in the deeds registry. And I think what that raises is not only a question of what technology can do, but I think it's about when the state intends to actually survey the land in South Africa, especially within rural communities, because failure to survey land is also a failure that will fall on failing to consult with the community effectively, because you need to know where they are, you need to know where they are based, and you need to know which community, where the community starts and ends in any kind of engagement. So when we talk about technology, I think about things like GPS mapping and all these wonderful things. But I think even with that, it cannot be used to curtail the true engagement of communities on a true on a meaningful basis. And then there was another question by Anonymous around the preservation of development of agriculture bill. I remember that bill being touted, and I understand why that needed to be. There was a huge call from the agricultural sector in the country with things like mining and development and economy to say, because agriculture provides us with food security, it ought to be protected and preferred in how land use happened or land decisions happen. And as you can see, we're already dealing with a tension between land developments, whether that's mining or any other economic developments, when agriculture hasn't been spared in that notion. You asked the question, is the Minister of Mining biased? I really think that, and I think that's the recurring theme again, and that's my opening remarks, is that the state is yet to provide leadership on land uses in the country. In other words, where do we protect our natural resources, our land that is good for the environment? Where is the leadership that says we are going to spare that land for those purposes, or land where there is a need for agriculture, so that there isn't this tension that is ultimately determined by the courts? I think it's really an issue of governance and planning that should be led by the executive, and that should be led followed by Parliament as well. And that speaks to Refilo's presentation as well around why do we have national legislation on planning, but yet we see in our everyday practice and in our everyday lives just tensions around what land is used for what purpose, and ultimately having to create a sense of leadership around those issues. So, and I think the issues of evictions also, again, those are the issues that show us socio-economic issues, the high unemployment rates, the joblessness, the economy dwindling, us being in almost a state of continuing economic hardships that has a direct impact on people being able to stay on land, on landowners having to bear the burden of these socio-economic issues by having to spend money in courts to evict unlawful occupiers. So really, just to tie in everything together for me, is that we have hopefully tried to place to the fore what critical issues that are facing our country, and how those issues are pronouncing themselves in the work that we do every day as lawyers. So, and unless I have missed a question on the Q&A, there are more that came through. Yes, I also wanted to address the question on the issue on technology. So over to you, Ati.
Thank you, Bulelwa. And I think you've addressed it quite extensively, just the use of technology in the public consultation process. So what we've seen is that, we've started to see polls, we've started to see ballots being used, voting ballots being used as part of the public consultation process, particularly to gauge where the community stands in respect of a particular mining or exploration project. We've also seen virtual, public participation consultations being available virtually on various media platforms. So there is room for technology to play a role in the public consultation space. That was all that I wanted to add. Thank you.
Thank you, Atsi. Temba Dlamini has asked a question on the Q&A around my views on the invalidation of the PPPFA regulations, and that it had an adverse impact on municipal entities, and which also means that, I think it means that money budgeted for a financial year may result in surrendering back to the national fiscus. This has serious implications for budget and planning. What is my position on this? So I really think that the Constitutional Court decision was a missed opportunity. Also, and sometimes, when courts receive a matter, they receive a matter based on the facts and based on the cases that are presented before it. But so courts are never going to be the leaders in how legislation, parliament, and the executive make decisions. But what I do want to say about that is that it is a critical moment for each municipality to reflect on what their municipal objectives are, and to include in those policies those objectives and those principles that are already inherent within Section 217 of procurement. Because ultimately, what does procurement seek to do? Procurement seeks to ensure that goods and services are procured in a cost-effective manner, that there's transparency, that the state doesn't bear an unduly high cost in procuring those goods and services. And of course, a huge element of that is a transformative agenda to ensure that previously Black people can, in fact, form part and parcel of a developmental state that we are in. So I don't think that the municipal entities should fold their hands now that we've got this Constitutional Court decision. I think that it is more instrumental and even more key for them now to have those policies in place that will still maintain those objectives that are still, they are already constitutional law objectives. So I don't believe that they are suddenly constrained by ensuring that there is this transformative agenda. I hope that somewhat answers your question. Do you want to? Yes, Tom wants to add something. Absolutely, please do.
No, I just wanted to quickly add something as well, just to piggyback on what Ati was saying earlier about the role of technology in consultation. I think technology, as Ati explained, certainly is valuable and can have a positive impact. I think what we can maybe take from Shell is just that one needs to ensure that the way that you use the technology is not exclusionary to any kind of communities, because in Shell, Shell actually did consult. There was a consultation process, but it was insufficient because There were newspaper adverts, but they were only in English and Afrikaans. There was no, many of the communities couldn't read English or Afrikaans. There were no radio adverts, which would have been an effective way of reaching those communities. But ultimately, the point is that if the way that you consult with these communities is exclusionary to any communities in the area, then it's insufficient. And it actually raises an interesting question, because how far do you actually have to go? What is the total extent of all the communities that you have to reach? And how far will a mining project have to, how far reaching does your consultation have to be? And I think that's, it's an interesting question, but I just wanted to add that, the way that you use the technology should not be exclusionary to any communities. Yeah, that's just what I wanted to add.
Great stuff. I'm not sure if there's anything else, but just on that issue of consultation as well, and what we've seen happen in practice a lot with developmental companies or mines, is that because of the mammoth task that is seen to when it comes to consulting with communities, what companies tend to do is that they will approach a traditional leader in the area and assume that to have been consultation on behalf of communities. I think there's a lot of legal texts now and even court decisions that have steered away from that idea, that paternalistic view that communities cannot engage directly. So it is that we'll find ourselves in that process where you actually have to do the work. I mean, we have a case in one of the biggest land claims in Mpumalanga where we literally had to obtain the signatures and resolutions of each member of the communities. And not only that, but to workshop, the reason for the development, when the development is going to happen and so forth. So it's not an information session. It's an engagement with communities in a meaningful way, so that you don't then have issues coming up later on the basis that communities weren't adequately consulted. So I think it's just a case of having to do the work and do the work honestly and sincerely. Yeah, so that's all from us, I think. Thank you for staying the course with us. It's been an absolute pleasure, and we will hopefully see you in our next installments of the land reform and tenure practice quarterly, is it? Biannually. So thank you very much, and thank you for your concentration and your engagement. We appreciate it.